Good afternoon, everyone, and thank you very much for joining us today for this episode of the monthly immigration uh, webinar, I guess you could call it. Today, as you know, the subject is visas for new residents and fellows, including J-1s, H1-Bs, and many more. It's actually more like, I would call it the alphabet soup, let's say, of visas. And so there may be a number of visas actually that you haven't heard about, but that you may actually run into with people who will be joining your program. So I know it's been a very hectic week for everybody, whether you're a physician who just matched for your residency program, or maybe you matched last month for fellowship. And then, of course, for program directors and program managers, coordinators, who have had a very busy time, all of you, I know, during this match season. And of course, now, especially with all the onboarding that you have to do, it's going to continue to be busy. So thank you all very much for taking time today to join the meeting. And as always, if you have any questions as we go through things, feel free to let us know, put something in the chat, and then I'm happy to answer them. My name is Michael Sherman, and I'm with Sherman Immigration PLLC. And as I mentioned last time, this actually marks the 30th year of my work as an immigration lawyer, specializing in healthcare immigration. So I don't know where the time has gone, but it's been a wonderful career so far, and dealing with all of you and your colleagues. And so thank you very much for 30 wonderful years in practice. I'd like to say a big thank you to my legal assistant, Carolyn Taylor, for all of her work in helping to put this together today. And also thank you to Jeff Bumbales, who helps with the technical aspects of things as well. So thank you both very much for helping to make today's presentation possible. And as mentioned earlier, as we go through things, if you have questions, let me know. Some of the visas will probably be very, very familiar to you, H1s, J1s, and then maybe some things not so familiar, things like DACA or L2S, E2S. Those visas, well, by the end of the presentation today, you'll be a guru or expert on all of these visas. So without further ado, we'll get started. Okay, so let's talk about J1s first of all. I know that all of you, especially those running programs or coordinating, are very familiar with the J1. So rather than really giving you the nuts and bolts, what I wanted to do today is to give you an overview, and especially for those who are new residents, new fellows, who may have heard of the J1 but are not familiar with it, just to kind of go over some of I guess give you a wide overview of what it is, what to expect, what it means, and what's involved. So the J1, as you know, it's an exchange visitor visa. I mean, that's the official term. And it's used for a wide range of different purposes. So not just residents and fellows, but as I indicate here on this slide, I mean, everything from professors and researchers to camp counselors and au pairs and even more. So it's really a multi-purpose visa. But for today's purposes, of course, we'll focus on J1s for residents and fellows. As you know, all J1s for residents and fellows are sponsored by the ECFMG, which is a quasi-governmental agency that sponsors all J1s for residents and fellows. And so even though J1s work at hospitals all over the United States, it's not the individual hospitals that sponsor the J1s, it's the ECFMG. As many of you know, or most of you know, there is a 7-year limit on J1 status for residency and fellowship. And while it is possible to sometimes go beyond that limit, you have to request specific permission from the ECFMG and explain your case and then hope for the best. It is difficult to get an extension, as you know, but all you can do is apply and explain the reason that you're seeking this extension. In addition, something else to note is a change of category, which we see once in a while. For instance, if someone is in the US as a J1 researcher or a J1 professor and now wants to start GME or graduate medical education, although the person's currently on a J1, the person has to seek permission and approval from the ECFMG for a change of category, because going from a professor or researcher to resident or fellow is a change of category that is not something that you can simply do by applying for a new DS 2019 to the ECFMG. So there is a specific and formal application process. Many times the application process goes smoothly. I would actually say most of the time, as long as it makes sense. In other words, as long as there's some type of connection between the research you are doing and the type of residency or fellowship that you're going to hold, there really is no reason for the ECFMG not to approve it for you. Let's talk a little bit about the J1 application process. So of course, because the ECFMG sponsors all J1s, that's really the starting point for new residents and fellows. You register, you take whatever steps you're required to take so that you're, first of all, ECFMG certified, of course, and second, so that they will then ultimately issue what's known as a DS 2019 form to you. The DS 2019 is the official J1 sponsorship form, and that's what you'll use as a new resident or fellow to either enter the US or to change your status in the US. So what happens is once you have the DS 2019 in your possession, you would then apply for a J1 visa or J1 visa stamp at a US embassy or consulate overseas. Now, this can be in your home country. Sometimes it can be in a different country. It depends on where you're residing and the rules of that local US embassy or consulate. The visa stamping process at the embassy and consulate involves filing an online application and usually also involves a personal interview. Now, these interviews can vary. I mean, some are 2 minutes in length, others are 10 minutes in length. They're not usually very long, but it's during that point that the officer will have the opportunity to ask questions about what you're coming to do in the US, and also about your ties to your home country. In other words, the J1, as you all know, and we'll address later on, is a temporary visa, and it does require the bearer to return home to the home country for a couple of years, unless the person obtains a waiver. So at the interview, there will be questions asked about intention to return home, likelihood of returning home. Usually, of course, the J1 stamp is granted, and then the person can use it to enter the US. Now, there is a very hard and fast rule in terms of when a J1 can enter the US, and it's 30 days. So 30 calendar days, during which time the J1 and family, if there is family, can legally enter the US. Can't be 31 days, it can't be 40 days. But the nice thing is about the 30 days, while the person cannot start working during that time, the person can definitely start making whatever necessary arrangements are needed to establish a domicile here, and take care of any logistics that need to be taken care of before actually starting work at the hospital. Now, the spouse and minor children, and that's really children under the age of 21, can obtain what's known as J2 status. J2 is simply the code used for spouse children of a J1. A spouse may be eligible to obtain what's known as an EAD card or a temporary work authorization card. That's something that the person would apply for, the J2 spouse would apply for separately once they're already in the US as a J2. Now, really the key to the J2 EAD, as we indicate in this slide, is that the requirement is that the Immigration Service must understand and agree with the fact that the income, any income that the J2 earns, is not needed by the J1 spouse for support. So again, the requirement is that any income the J2 earns has to be extra, over and above what is required for the J1 spouse to live in the US. So things like rent, food, other necessities of life, that the J2's income cannot be necessary or needed for those expenses. In terms of getting renewals, as all of the program managers and coordinators and directors know, and of course, this would be new for any new residents or fellows who are joining. But once a person is admitted to the US as a J1, thankfully, the annual renewal process is very straightforward and thankfully does not require a trip outside the country or any other involvement of the US Immigration Service. Instead, it's really up to the ECFMG. An application process with the ECFMG is very straightforward and ultimately results in the ECFMG issuing a new DS 2019 to the J1 holder and also spouse and children if there are any. So every year, as long as the ECFMG issues new DS 2019 forms, the J1 and J2 are considered to be in valid immigration status or valid visa status in the US. Now, that's important because when a J1 and J2 folks enter the US, they are registered for an I-94 card, which used to be actually a paper card that was stapled into each person's passport when they landed in the US or entered through a border point. But I-94 cards are no longer given out in 99% of the cases. And instead, the officers at the airport or at the border will simply tell everybody, look, when you enter the US, get to a computer and a printer and print an I-94 card from the US Customs and Border Protection website. So that I-94 card is really the official evidence of a person having been lawfully admitted to the United States, and their visa classification, and also the duration or expiration date. However, for J1s and J2s, there actually is no expiration date listed on that I-94 card. Instead, it will say DS or D/S, which means duration of status. And so what that means is that as long as the ECFMG has issued a DS 2019 to the J1 and the J2, those people remain in valid J1 or J2 visa status in the US. So in the old days, when I was a very young immigration lawyer, the I-94 card always had an expiration date, and it coincided with the expiration date of the person's annual DS 2019 form, or what actually was then known as an IAP 66. Starting about, I would say, 15, 20 years ago, the Immigration Service started issuing DS, or listing DS as the expiration rather than an actual expiration date. And part of that was probably so that the Immigration Service did not have to process annual J1 and J2 extension applications from all of the residents throughout the United States. Again, as when I was younger, we were constantly filing a ton of such applications every year. And of course, immigration had piles and piles of applications to adjudicate. This current policy is terrific because, again, it allows a person to renew the J1 or J2 without having to deal with the Immigration Service. At the end of the person's training, there is that 2-year requirement, which we'll talk about in just a minute, and many of you are probably familiar with it, but we'll kind of take a deeper dive into it to see exactly what's involved. Okay, and speaking of the J1 2-year foreign residence requirement, which is also known as Section 212E. So for anyone who holds a J1 visa stamp in the passport or J2 stamp, at the bottom there is usually a notation, and it will say something like Section 212E applies or Section 212E does not apply. Sometimes it will also go on to say the 2-year requirement applies or the 2-year requirement does not apply. So when you see Section 212E, that's actually the section of the immigration law, the US statute, that talks about this requirement to return to the home country. So to start with, everyone who holds a J1 for graduate medical education and also their spouses and children are automatically subject to the requirement that they all return to their home country for a period of 2 years. Now, a couple things about the home country. Maybe actually to start with, what is the home country not? So this means that you cannot return to a country of your choice. In other words, you have to leave the country for 2 years, and you've always wanted to go to France or Brazil or wherever. You cannot fulfill that requirement by going to a country that you simply choose to go to. Instead, you must go to the country of what's known as the country of your last permanent residence, as listed on your DS 2019 form. Now, this may or may not be the country of citizenship, but instead is usually the country where the jumping off point, so to speak, the country that you last permanently resided in before coming to the US as a J1. Now, of course, often that is your country of citizenship, but in certain situations, it's not. So it's very critically important that all J1s and J2s look carefully at their DS 2019s, see what is listed as the country of last permanent residence, and then know that that's where they have to go in order to fulfill the 2-year requirement. Now, while a person is fulfilling that requirement, it is possible for the person and spouse, kids to visit the US on a temporary basis using a visitor visa. But it's really important to know that any time that people spend in the US has to be added on to the 2 years. So if they come here for a week vacation, or let's say the J1 is coming here to make a presentation or a speech or attend a conference for a couple days or a week, that time has to be added on to the 2 years that they must spend outside the US. Because the burden of proof is always on the J1 and the J2 to show that you have fulfilled the requirement, it's important that you document absences from the US. Well, of course, the absence, but also anytime you spent here, it's important that you also document the fact that you're spending extra time back in your home country to fulfill the 2-year requirement. Now, with that being said, as many of you know, maybe most of you, many people try to obtain a waiver of that requirement. In other words, rather than fulfilling it by going home for 2 years, there are ways to obtain a waiver. For example, obtaining post-graduation or post-residency fellowship employment with a Veterans Administration facility or hospital, or obtaining work for a period of 3 years with a hospital or medical practice that's located in a designated medical shortage area of the U.S. Other ways are if you can prove that you have a well-founded fear of persecution if you had to return to your home country, or if returning to that country would pose an exceptional hardship on your U.S. citizen spouse or U.S. citizen children, if you have a U.S. citizen spouse or children. So these are just some of the ways of obtaining a waiver of this requirement. Now, we won't go into too much depth now on these waivers. We're going to cover them in a future session. But the most important thing to note, really, two things. Number one, it is in some cases very possible to obtain a waiver in return for instance, working at one of these locations for a period of 3 years, or again, proving persecution or exceptional hardship. Now, as an aside, and the following really only applies to people from Canada. There are two additional options that Canadian citizens have. And I say this because, especially one of them, because we are in a border state, we border with Ontario. So this does come up a lot. So the first thing is some people who accept a local job here, post-residency or fellowship, if they reside in Canada for 2 years and commute to their U.S. job for 2 years, and that's commuting on a daily basis, they actually do two things at one time. They get to work in the U.S. as an H-1-B worker, while at the same time fulfilling that 2-year rule by residing in Canada. Now, it's important to note that the daily commute really does mean daily commute, because over the years, people have asked me, well, what if I come in on a Monday to the U.S., stay here, and then go back every weekend? Or if I come in for 3 days and leave for 4 days? Honestly, you can't do that. There are records at the border as to exits and entries, and also the burden of proof is on you to prove that you actually did commute to work on a daily basis. At the end of the day, the burden is always on the J-1 person to prove that you fulfilled the J-1 2-year requirement. So you'll need to keep records that, yes, you did commute. Again, it's up to you. And the other way, or the other thing I wanted to mention also, is that for Canadian citizens only, it is possible to obtain an H-1B work visa and actually reside in the U.S. Without a J-1 waiver. As strange as that may sound, it's just the way that the law was written. However, it's really important to know the following, that doing so does not get rid of the J-1 2-year foreign residency requirement. It simply defers it. I mean, at some point, you'll have to fulfill it or obtain a waiver. So very few people actually do what's listed at the bottom of this slide, which is to get H-1B status, come and live in the U.S., knowing that that 2-year requirement is hanging over their head, and at some point, they're going to have to get a waiver or fulfill the requirement. So very few people do that, but there are a lot of Canadian citizens who do live in Canada and commute daily to a U.S. job. Although that is definitely a hassle to cross the border every day, it does fulfill the requirement, and it then allows them to move to the U.S. at the end of the 2 years, obtain a green card, and then they've taken care of the requirement. So just a very quick pros and cons of J-1 status. USMLE is not required, as you all know. The spouse, the J-2 can get an EAD card, and the return requirement, the requirement that you return home for 2 years, can be waived if certain requirements are met, and the application process is very straightforward. The cons, of course, the big one, the main one, is the 2-year home requirement, which we've discussed. Also, it's a single intent visa, so kind of goes hand in hand with this 2-year requirement that you're only supposed to have the intent to be here on a temporary basis and not to get a green card. And of course, the 2-year requirement actually gets in the way of getting a green card, because you have to fulfill that requirement before you can be approved for a green card. And lastly, as mentioned a couple minutes ago, you have to show an intent to only be in the U.S. temporarily. There is one additional note, and it is in the slide. I didn't mention it, but wanted to now. For Canadian citizens only, they are the only people in the entire world, actually, who are exempt from getting a J-1 visa stamp from a U.S. embassy or consulate. So if you have a person who's a J-1 citizen once they get their DS 2019, they can actually skip the embassy and consulate procedure altogether and simply apply for admission at a border entry point or at an airport for admission as a J-1 or J-2, and that's great. So skipping that consulate and embassy step is huge. That process can be a bit of a hassle, and so the fact that they're allowed to simply enter is very helpful and helps to streamline the process. Okay, now switching gears, let's talk about H-1Bs. Some hospital programs do offer H-1Bs, others only the J-1. So let's do an overview of the H-1B so that people who are eligible to get them, their programs or hospitals offer the H-1B, know what the H-1B is all about. So just to start out, the H-1B is known as a visa for specialty workers or specialty occupation. And the definition of specialty occupation is a job that requires at least a U.S. bachelor's degree or a foreign equivalent degree. And also the person, of course, must meet that degree requirement. So, of course, resident and fellow jobs are definitely meet the H-1B requirements because the medical degree is required. Now, just as a quick note, I mean, this doesn't really impact residents or fellows, but a question I often get is, well, can't I just enter, can't I just establish a business in the US and self-sponsor my own H-1B? The answer is no. And I won't get into the details, but it is a question that comes up. It also comes up in the context of spouses of residents and fellows who they themselves would like an H-1B, and they may have some type of business idea and wonder if, while the resident is doing the residency or fellowship, whether they can set up their own business, self-sponsor themselves for the H-1B. Unfortunately, the answer is no. Now, the nice thing about the H-1B is it's portable from job to job. In other words, you do your residency and then the new job that you have, the post-graduation job, can sponsor the H-1B transfer. There is a 6-year limit of H-1B status, and you have to leave the country at the end of the 6 years. And then if you do that, leave for 1 year, it resets the clock back to 0. You get another 6 years of eligibility. It's also possible to actually go beyond the 6 years in certain circumstances. Generally, if you have an I-140 approval, or if you've held H-1B status for longer than 6 years, but it's really tied into the green card process. And so there's no way to go beyond the 6-year limit unless you are in the green card process. And in terms of residents and fellows, those positions do not qualify to serve as the basis for the green card process. About 15 years ago, the U.S. Department of Labor issued a formal ruling that residency and fellowship positions cannot be used as the basis for the green card process because they are in temporary positions and not permanent positions, and hence don't qualify for the green card or to serve as the basis for the green card. Spouse and minor children of an H-1B get what's known as an H-4. And the spouse on an H-4 can sometimes apply for an EAD card, just like the J-2. However, a couple differences. Number one, the main thing is that the H-1B worker has to have an I-140 approval. Now, I-140 is part of the green card process, and so very, very few residents and fellows will have an I-140 approval. There is a possible way to get them for aliens of exceptional ability or whose immigration is in the national interest. But for the most part, most starting out residents, of course, don't have an I-140 approval. And so the spouse and children will get the H-4. The spouse will not be eligible to get a work authorization card or EAD card. Now, a question I get is, well, what can the spouse and kids do while they're here if the spouse doesn't have work authorization? Well, first of all, they can volunteer. But the volunteer position that the spouse or even kids would hold has to be a position that is a normal volunteer position, like working for the Humane Society or at a local library. It can't be things like volunteering to serve as a doctor or volunteering to serve as a researcher or volunteering in a laboratory. It cannot be any job that is normally a job that is held by and is normally held by a U.S. worker and is normally paid. So it has to be a position that is always volunteer, again, such as Humane Society or something similar. Now, the H-4 children, of course, can go to school while they're here, and actually the spouse can too. If the spouse wants to go back to university or do some other type of education, that's allowed as well. So the application process, I'll just go into it for a moment and not spend too much time on it, but it does involve two separate filings, one with the U.S. Department of Labor, which is the LCA, and then what's known as the I-129 with the USCIS or Immigration Service. The purpose of the Labor Department form is just so that the Labor Department can confirm that the person is going to be paid the usual or prevailing wage rate, and that the person is not being hired to replace a striking or locked out U.S. worker. The Immigration Service ultimately has the final approval. Once they approve the I-129, then the H-1B approval notice is issued. If the person is already in the U.S. As an H-1B working for a different employer, then there's no need for that person to leave. They would simply, the new H-1B approval notice sponsored by the program would simply allow an easy transition into the program at the hospital without the need to leave. And also really the same goes if someone holds a different U.S. visa status, such as if they're an F1 student, for instance, and are now transitioning into a residency position. So the nice thing is they can stay in the U.S. Immigration will, or USCIS will issue the type of approval notice that will automatically allow them to start on the starting date without first having to leave. Now, just as an aside, this type of approval notice is not a visa stamp or sticker in the passport. And the reason that's important is that when these folks seek to leave the US for the first time, maybe it's for a family vacation, maybe it's for a conference overseas, they will need to obtain an H-1B visa stamp for their passport. Same goes for any family members. They would need to obtain an H-4 stamp for their passports in order to return to the US. So the USCIS does issue these H-1 approval notices, but does not issue visa stamps. Those stamps can only be issued by the U.S. Department of State, and that's done through U.S. embassies and consulates overseas. Now, just as an aside, the State Department has started a pilot program where certain people can get new H-1B visa stamps if they've already had them in the past without leaving the country, and that's by sending their passport and application documents to the Department of State's headquarters in Washington, D.C. Currently, it's a very small number of people who qualify for that, but ultimately we're hoping over the coming years that more and more people will qualify for this, that they expand this pilot program, and so that less and less people will have to take the time to go to a U.S. embassy or consulate and obtain such a stamp during their overseas trip. Now, Canadian citizens, again, are treated a bit differently. They don't have to get a visa stamp. And in fact, they really won't be given one, even if they try to apply. So instead, they take the H-1B approval notice, they go to the border or fly to the US, and they're granted entry as H-1B workers without having to go to the embassy or consulate for a visa stamp. Now, as you know, J-1 workers can enter the US up to 30 days in advance. H-1Bs, only 10 calendar days in advance. And as always, the Department of Homeland Security is very strict about the 10 days. So it's not 11 days or 12 days, but it's 10 days, 9 days, 8 days, that's all fine. But 10 days would be the first. So for instance, if your program starts June 24th, June 14th is when they can legally enter the US. Now, they cannot work during those 10 days, but can simply take care of whatever logistics they need to take care of in order to be ready to start work on the starting date with the program. Now, residency programs are always more than 1 year, of course, and some fellowships are as well. And the reason I mention that is whenever we apply for an H-1B visa for a person who only holds a temporary state medical license, the Immigration Service regulations allow the service to limit that person's H-1B approval to a period of just 1 year. Now, they don't always do that. So for instance, if someone has a 3-year pediatrics residency that they're about to start, my normal procedure is to apply for all 3 years because there is no harm in requesting all 3 years. For the most part, lately, I would say over the last couple of years, the Immigration Service has actually been granting the full 3 years most of the time, even though the person just holds a 1-year license. With that being said, some years ago, it was the usual amount of time was 1 year. So in other words, we would apply for the full 3 years, knowing that in all likelihood, what would result would be the Immigration Service just granting a 1-year H-1B. So thankfully, the trend is for multi-year H-1B approvals. But again, once in a while, we still see a 1 year. Seems to be no rhyme or reason why one person in a program would get a 3-year while another person would get a 1 year. It doesn't seem to depend on what country they're from, where they went to medical school, or really anything else. It just seems to be, I guess, maybe which officer's desk the application lands on. Now, that's with temporary visas. If a person or when a person holds a permanent license, and that could be for fellowship, um, then the Immigration Service will automatically grant the full amount of time. So if it's a 3-year fellowship, the person holds a temporary license, that's terrific because we're confident, we know that for sure they will get a 3-year H-1B with no problem at all. For those who do need an extension, it's a very smooth process usually. It's done entirely in the US. It's very similar to the initial process. The person does not have to leave the country for this and can continue working. And that's really important so that there's no interruption in your program. If you're running the program there, you don't have someone who has to leave the country for a week or two to obtain a visa and then come back. Moving on. So the H-1B cap is something I just wanted to talk to you for about a second on. Some of the folks, those programs that offer H-1Bs, you may have residents or fellows asking you about the H-1B cap, and specifically one question: is the hospital subject to the H-1B cap? So thankfully, in at least 99% of the cases, the answer is no. So what is the H-1B cap? Well, just very quickly, by law, the statute limits the number of H-1Bs that can be granted each year. So there are 65,000 H-1B visas that can be granted, plus another 20,000 H-1B visas for people who hold at least a U.S. master's degree. And it has to be a U.S. degree. Now, those visas are available for just about any employer, whether it's General Motors or McDonald's Corporation or what have you. And the issue with that is that because there's such a large demand for such visas, there's a lottery held every year at the end of March. And during that lottery, the winners are picked. Most applicants, unfortunately, do not get a visa because, again, as you can see, the number of visas is limited. Now, thankfully, most hospitals are exempt from this cap or limit. And what that means is that these hospitals or entities can obtain H-1B visas throughout the entire year, totally irregardless of whether the lottery has been held, whether the 85,000 visas have been issued. It absolutely does not matter. So what makes these hospitals exempt from this lottery? Two things. Number one, they have to be nonprofit, which means designated as nonprofit by the Internal Revenue Service. And number two, they have to have a written and active affiliation agreement with either a medical school or some other type of institution of higher education, some university, nursing school, or what have you. And with those two things in place, the H-1B visa for that resident or fellow is 100% exempt from the cap, and hence no worries about the lottery, because that exemption allows the hospital to file the H-1B application any time of the year, and the lottery is totally irrelevant. Just quickly, pros and cons. So with the H-1B, really the main pro as far as residents and fellows are concerned is the no return home requirement. And they're not subject to 212E. So they can simply graduate, and if they're able to find employment in the US, that's terrific. The new employer, if they meet certain requirements, can go ahead and apply for an H-1B transfer and no problem at all. Also, if they should be running out of time, let's say they do a 3-year residency and a 3-year fellowship, they can leave the country for a year if necessary and reset the time, make themselves eligible for a new 6-year period of H-1B visa status. H-1B is a dual intent visa. It's one of the very, very few that is an official dual intent visa. And what that means is that the bearer has the intent to work temporarily in the US while also intending and even taking steps towards getting a green card. Thankfully, getting a green card is not a problem with an H-1B because they can have those two intents simultaneously. And lastly, of course, portable from one job or employer to the other. So very portable from a residency or fellowship to a post-residency or post-fellowship position. The cons, 6-year limit. It's more costly, and the employer by law is required to pay for all of the H-1B costs. Some employers are subject to the H-1B cap, although most hospitals, thankfully, are not. But in terms of paying the costs, years and years ago, the regulation was always there that employers had to pay. But until approximately 2009, that part of the law was really never enforced. And so prior to that time, many programs around the country were okay with the residents and fellows, or perhaps friends or family members, paying the costs of the H-1B, the attorney's fees, the filing fees, and it was not a problem. Starting around 2009, there was increased enforcement of this requirement, and it's at that point that programs started requiring that, or actually I should say allowing H-1Bs only if the program itself was willing to cover the costs of the visa. Okay, so now let's move on to more of what I call, I guess, the alphabet soup of visas. And these are things that you will run into here and there, but apart from the H-1B and J-1, they're not necessarily the things that first come to your mind when you think about visas for residents and fellows. Now, these visas are not sponsored by the ECFMG. They are not sponsored by your program. So if you look at it this way, I mean, these are types of visas or statuses that people will present to you. New residents or new fellows may say, I have something like TPS, which is what we'll talk about in just a second, or I have DACA, or I am a refugee. So with that being said, there's no application for the program to fill out, nothing really that the hospital needs to do. So let's talk about TPS first, or temporary protected status. This is a type of status. I mean, I call it a status, but it's not an official visa status like an H-1B is a status or a J-1 is a status. Instead, it's really a grant of permission for someone to remain in the United States on a temporary basis based on home country conditions in their home country. Now, this only applies to people who are currently in the US. So maybe they entered as a visitor, or maybe they entered the US as an F1 student, or even as a J-1 or H-1B. And what happens, or what has happened in their home country, is let's say a typhoon or a civil war or some terrible thing that in some way has the U.S. Department of Homeland Security allowing those folks to remain in the U.S. so that they don't have to go back to dangerous conditions. Now, there are a certain number of requirements, which we'll go over in a second, but those folks who are granted TPS, and this is something they affirmatively must apply for during the application period, they're able to get an EAD work card. Again, it's something they have to apply for, and then they can work. Now, the nice thing about the EAD card is it's not limited to any specific employer or any specific job or location. They can work anywhere in the US. And what that means is, of course, that they can join a residency or fellowship program using that EAD. So a couple things, of course. TPS is granted in certain increments of certain number of months, and they must, the TPS holders have to reapply for a renewal of their TPS and also renewal of their EAD card. Now, countries that are currently designated for TPS are listed at the bottom of the slide. They include places like Afghanistan, Burma, Cameroon, Ukraine, Venezuela, Yemen. And from time to time, the State Department is required to review this list and to review current country conditions in that country. And the goal is at some point for the State Department and Department of Homeland Security to determine that country conditions have changed back home to the extent that it is now safe for people from that country or those countries to return there. So TPS is not something that will be permanent, and it is really an unknown as to how long it will continue for each country. I will say, however, that the countries on the list have been TPS for many, many months. The newer ones on the list, like Ukraine, it's probably been a couple of years, but others, it's been a number of years. So it's not as if there's a specific ending point, like, oh, TPS for this country will end, exactly in 1 year. It's something that's under constant review. So TPS pros and cons. TPS can be renewed indefinitely as long as the conditions don't change in the country. The conditions are still dangerous. And you can actually change from TPS to another visa or green card. And that's really an important thing. It's kind of an anomaly in immigration law because usually you have to be in a valid status like H-1B, F1 to change from one status to another or to change from one status to a green card. With that being said, the regulations allow a person holding TPS to change to an H-1B or a green card, even though the person may have entered, let's say, as a visitor, and that visitor status ended and the person overstayed, but is in valid TPS. So that's a huge benefit. The cons, you have to be a national or citizen of the country where all this unfortunate stuff is going on. You have to be in the US already. So TPS is not something that you can affirmatively apply for while you're residing outside the country, whether you're still residing in that country where you're from or even a different country. And in addition, a country can be removed from the list at any time. I mean, there definitely is advance warning of a number of months, and that way the TPS holders can plan on whether they have to go home or can they change to a different type of visa status so that they can continue living and working in the US. Next, H4 with EAD. So as we mentioned or talked about earlier, certain H4 spouses, and those are spouses of someone who holds an H1B, are eligible to apply for a temporary work card or EAD card. There are only certain circumstances when they're eligible for that. But the nice thing is that this EAD allows them to join your program or to really hold any other job in the US. So H4 again is granted to spouses and children under 21 of H1B holders. And H4 status is granted for the same amount of time as H1B visa status. The EAD can only be applied for and granted to an H4 if the person holding H1B, that is the H1B spouse, has held H1B status for more than 6 years or has an approved I-140. And both of those two prongs or routes are part of the green card process. So this is not for someone who is entering the US as a new resident or a new fellow, and this is the first time they're holding H1B status. I do get the question a lot from new residents, saying that they're going to be entering with an H1B and can they get their spouse H4 EAD? And the answer is, unfortunately, they can definitely get H4, but not an EAD. Now, what is the EAD? I mean, the official term EAD, or Employment Authorization Document, it's really not a document. It's just a small plastic card that allows for employment authorization. And again, as mentioned before, this type of EAD, along with J2 EAD, and also TPS EAD for that matter, allows the person holding it to work in any US state, at any job, at any rate of pay, or even for multiple jobs. So it's not limited. For instance, the H1B, as you may know, is limited to a specific job with a specific employer, as is the J-1. And the H1B is also limited to the fact that the H1B must be paid at least the prevailing wage rate or usual wage rate for that type of position in the geographic area where it's located. EAD has none of those requirements. And so it definitely can be used by residents, fellows, and others. EAD cards, and this goes for all EAD cards, definitely expire. So it's important to know the expiration date. And also the burden is on the bearer, the person who has the EAD, to make sure that they apply for a renewal of the EAD on a timely basis. That's their responsibility. So H4 EAD pros, it's an easy renewal process. It doesn't tie the person to a specific employer or job or rate of pay or hours per week. The cons or downside, of course, as we talked about, is a very limited number of H4 folks qualify for this because their spouse must have held H1B status for quite a while or have an I-140, which again is part of the green card process approval. EAD processing, like a lot of things in immigration, can be slow. Okay, moving on. F1 optional practical training. So this is something that you'll see specifically when your new residents are graduates of a US-MD or DO school. As part of the F1 visa for these folks and also others who are graduating from other programs, other educational programs, bachelor's degrees, master's degrees, they're normally eligible for a 1-year period of work authorization. It's known as OPT or optional practical training, and the purpose is to give this person a 1-year period of work experience in the field. So they just completed a medical degree, and this grants them a 1-year period so they can go ahead and use this degree to work in the US. So for those folks who have an F1, they can apply for OPT, and that comes in the format or the form of an EAD card, which we've just discussed. It's valid for 1 year, and so they can use that to start your program. And the key thing to really note is this type of EAD is valid for a 1 year period. So actually, a couple things that are important. Number one, the F1 student needs to apply for the OPT as early as legally possible. There are specific time parameters during which applications are accepted by the Immigration Service. So although I'd love to tell everyone to apply months and months in advance, that's not possible. The good thing is that the Immigration Service usually processes these applications on a timely basis. Now, it's important that the starting date on the EAD be on or before the starting date of your program. So if your program starts June 24th, and the EAD validity doesn't start until July 3rd, well, the problem is that the person cannot legally work for your program, cannot join your program until July 3rd. Now, for the most part, EADs are valid starting well before that, usually mid-June, let's say. So usually there's no problem with the person getting the EAD on a timely basis and starting your program on the normal starting date. The final important note is, while this is a good way to start a residency, ultimately, the program and the resident will need to work together to determine a way forward, to plan a strategy for covering the rest of the residency, whether it's changing to a J-1 or changing to an H1-B. This type of strategy should be worked out at the beginning of the residency so that over the subsequent months, whatever steps that need to be taken can be taken on a timely basis so that there's no interruption in the person's ability to work for the program. EAD cards, especially in this instance, when they expire, if the person does not have a new work visa or a new EAD, the person will literally have to stop working until they have a new visa, a new EAD, H1-B, J-1, or whatever. And so planning has to be done carefully to make sure that the necessary steps are done timely so that there is not such an interruption. Pros and cons. So F1 pros helps the resident transition from med school to the residency program very easily. Does not require the program to do anything or to file any applications. It gives both the program and also the physician or the resident time to figure out which is the optimal visa or which visa or visas the program is willing to sponsor. And it is possible to use premium processing for the OPT application or the 765 form. So what are the cons? It only covers 1 year, as we all know, and requires that the person must have earned their degree, whether MD or DO, at a U.S. institution as an F1 student. So it's a limited audience or limited group of people that qualify for this F1 OPT. And while the medical school or university may limit the OPT to just a specific employer or specific job, normally U.S. medical schools don't do that. I can't actually think of any instance in the past where I've seen a medical school place such a limit on an EAD. With that being said, just as an aside, there are other times when, let's say, a person earns a computer science degree where the university actually does place a limitation on the use of the OPT and specifically says, okay, this OPT can only be used for work at General Motors, or this can only be used for work as a computer programmer or software developer only. But we usually don't see such limitations on F1 OPT. Okay, so moving on, let's talk about DACA. DACA is something that I'm sure you've all heard about. It's been in the news for several years. It was something that was started by President Obama, and it continues through this day. And DACA is specifically not a visa status. It's more of I would say permission for a person to remain in the U.S. legally without fear of deportation. It's really a protection from being deported for certain people who were brought to the USA as children. So they no longer have to worry about being picked up, deported, placed in deportation proceedings, or what are now known as removal proceedings. It also allows them to get an EAD that can be renewed every couple of years. So currently the DACA program is valid indefinitely. That may or may not change in the future. It's up to each presidential administration and also Congress to determine what the future of DACA will be. In the meantime, it is out there, it is valid, and to get DACA, there are 7 eligibility requirements. We won't go over them, but they're listed here. At the end of the day, a DACA, a person who's been granted DACA and an EAD, is, like everybody else who holds an EAD, eligible to start the residency or fellowship. But again, I mean, as with other people holding EADs, it's important to figure out, okay, what does the future hold? I mean, this type of EAD for DACA, as long as DACA continues, the person can continue using the EAD. Hopefully it will be in place long enough for the entire residency or fellowship. But at this point, no one really knows what the future holds. And it's just a kind of a it remains to be seen what will happen. DACA pros and DACA cons. DACA pros, it's currently valid indefinitely, allows a person to live and work in the US without fear of deportation. And again, work authorization, any job, any employer, anywhere in the US. The cons are you have to meet all of the 7 eligibility requirements, and currently there's no path to citizenship. From time to time, Congress or members of Congress will talk about trying to establish a legal basis from DACA to US citizenship or from DACA to a US green card. There have been many proposals over the last several years, none of which unfortunately have come to fruition. So it's really something to stay tuned to, but at this point, there is no path. Once you're DACA, that's really all you are at this point, and there is no specific path to making your status permanent, at least not at this time. Limits on travel outside the USA. I won't go into too much depth on that. And same thing with DACA also. DACA is DACA, and it's not possible to change from DACA to H1-B or to J-1 or anything else. It allows for work authorization, but that's really where it stops at this point. So let's go over just very quickly some less common visas that you may run into. Let's talk about L2S, first of all. So there are visas known as L1, and that is used by US companies to sponsor managers, well, executives, managers, or what's known as specialized knowledge employees from foreign related companies to the US company. So for instance, let's say Ford Motor Company wants to transfer a manager from Ford Motor Company of Canada to work here in the US. They would use an L1 visa to do that. Or let's say there's an employee at General Motors of Canada who has specialized knowledge about some type of proprietary software program that just that company uses, and the US parent company wants to bring that person here to the US to implement that at the US company. So L1 is what they would use. Spouses traditionally get what's known as an L2, and so do the children under 21. L2 spouses used to have to apply for an EAD card so that they could work in the US if they wanted to work. And the downside with that is it used to take several months, sometimes, for the EAD to be approved. Thankfully, within the last couple of years, the Immigration Service has determined instead that based on the law and the regulations, that getting an EAD card is no longer necessary. And instead, the L2 status itself is enough for someone to work in the US, and that's work for any employer, any job, any state in the country. And so the way that they denote that now is traditionally they would give L2 status. Now it's L2S. And so the L2S is to let everybody know that this is the spouse of an L1 worker and that the person is eligible to work in the US for as long as the person holds this L2 status. Now, along with that are E visas. So there's E1, E2, E3. Their spouses are granted E1S, E2S, E3S. So E1 and E2 kind of go together. Those require treaties between the United States and the person's home country, whereby people from the foreign country can open US businesses and can staff them with certain folks from back home. For instance, many years ago, I represented a British engineering company that set up a US entity that did very advanced automotive design work using some proprietary software. And what they would do is use the E1 or E2 to bring certain British engineers who were experts in this new technology to the US to help this company. E3 visas are totally different, and they're actually very interesting. E3 has absolutely no relation to E1 and E2, and instead it's limited to citizens of Australia who want to come to the U.S. to hold a specialty occupation. Now, you may remember from a little while ago, we talked about how H-1B visas are for specialty occupations. Well, so is the E3. The nice thing about the E3 is that while it's very similar to the H-1B, it's really just a one-step visa. That's where the employer would file just the LCA that we talked about and not have to file anything with the Immigration Service. Once the LCA is certified or approved by the Department of Labor, you would ship it to the Australian citizen. The Australian citizen would apply to the U.S. Embassy in Australia for an E3 visa, and then would be granted the E3 and allowed to enter the U.S. So the nice thing about the E1S, E2S, E3S, and these are the spouses, they can, like the L2S, work in the U.S. Without an EAD card, any job, any employer, anywhere in the U.S. People often ask me how many E3 visas are granted each year, and actually the number is surprisingly low, which I'm not really sure of the reason for, because it is a very easy visa to get and requires a lot less work, a lot less costs than the H-1B visa. Okay, asylees and refugees. You may have heard the term asylum and refugee, and so there is a bit of a difference, but as you'll see, it's kind of all where you are when it's granted. So what is an asylee? An asylee is a person who lives in the U.S. and has been granted asylum, or what's officially known as political asylum. Asylum is a permission to live in the U.S. and ultimately to obtain a green card for various reasons, so that the person does not have to go back to the home country. Now, refugee or refugee status is a person who is outside the U.S. and who is applying for asylum or refugee status and has been granted the refugee status based on the U.S. government's finding that it would be dangerous for the person to live or remain back home. So an asylee is someone already in the U.S. Refugee is someone who's outside the U.S. but who's allowed to enter the U.S. And in both situations, both are allowed to work in the U.S. for any employer at any job without an EAD card. Now, ultimately, they will all be able to apply for green cards. There's a specific number of limit on how many folks can apply for this type of green card every year. But in the meantime, both types of people are eligible to continue working in the U.S. until such time as they can apply for and obtain their green card. And then, of course, the green card allows them to live and work here permanently. So in the old days, there was a question of whether these folks had to have an EAD card. There was a difference or a differing of opinion. And ultimately, the government finally came out and said, no, they don't. They're allowed to apply for an EAD card, but there's no need to. And because it's totally optional and there's no need to, no one does anymore. I mean, simply would be extra cost and expense and for really no benefit. Okay, so just a quick heads up on our next session, which will be next month on April 18th. And then any questions that you may have, I'd be happy to answer. But next session in April will be on visa options for Canadian citizens. And as you've already seen from a little while ago earlier in our conversation here, there are certain visas or situations that are applicable to Canadian citizens specifically. Certain benefits they get, and that's simply because of the way that the laws were written, or perhaps things were not taken into consideration, such as certain states like Michigan and others are close to the border. And so things like having people commute to the U.S. daily from Canada may not have been at the top of the law writers' minds when they were drafting the laws that talk about J-1 and the requirements in Section 212B. So we hope that you'll join us on April 18th for the session. And in the meantime, if you have questions, any questions? Okay, great. So with that being said, what I'd like to do is conclude today by thanking you all very much for joining us. It's been a pleasure, as it always is every month. And as always, if you have any questions, please feel free to contact us at any time. My email is on the screen, and so is the phone number, and also our website, which we hope you'll access and take a look around. And it will ultimately have a copy of today's presentation and other information that I hope will be helpful. So thank you again all very much for joining us. Appreciate it very much, and hope that you have a great rest of your day and a great rest of your week. Thank you all very much.